I'm Sally. In the last video, I explained the importance of a will, how to choose the right executor, and issues regarding the guardianship of children. I received a lot of support and thanks from many friends, and I believe everyone now has a preliminary understanding of estate planning. Now let's continue to understand more. Besides the will, what other factors need to be considered? In our planning, we can make arrangements that allow us to decide how to manage and distribute our assets. This can simplify and speed up the asset transfer process and minimize the tax impact. If you're interested, please continue watching with me. I use the Canadian government's official website as a reference. On the estate planning homepage, there is a checklist that lists the contents the government recommends considering for estate planning. Let's refer to this checklist together. First, the most important thing is to leave a will, which was the main content of my last video. If you haven't watched it yet, I highly recommend you go back and review it. The content of the last video is extremely important. Second, name a beneficiary for insurance and other policies. When we purchase insurance or open registered accounts like TFSA or RSP, make sure to choose a beneficiary. Upon death, these assets can bypass probate and go directly to your beneficiary. You can also designate a contingent beneficiary in case the primary beneficiary predeceases you. Regarding the issues of how to tax registered administrative accounts and how to choose beneficiaries, I have provided a more detailed introduction in my previous video about various savings accounts in Canada. The third and fourth points are to plan your funeral and prepay your funeral expenses. In most cases, people might be reluctant to consider this issue, but making arrangements and prepaying in advance can help reduce some expenses for your family when the time comes. This can alleviate some of the stress and burden on your family to a certain extent. The fifth point is to buy life insurance to cover expenses. This is the second time insurance is mentioned. As I mentioned before, when a person passes away, all assets under banking law will be frozen until the corresponding taxes are paid and all debts are cleared. Only if there are no disputes regarding the distribution can the assets be distributed according to the will or the law. When a person passes away, the final tax return is essentially a huge tax bill, and the amount will definitely exceed your expectations. If there are no ready funds to make these payments at that time, the estate distribution cannot proceed smoothly. This often leads to the need to sell off assets to repay debts. This is a real situation that has happened around me, where someone owned several investment properties and ended up having to sell them because they couldn't pay off the loans after passing away, and the tax consequences of capital gains. Several investment properties all need to be auctioned off, and a lifetime of hard work goes down the drain, leaving the family feeling very helpless and truly pitiful. This further highlights the importance of life insurance, because when a person passes away, if there is a designated beneficiary, the death benefit is completely tax-free and does not need to bypass probate. After submitting the application, it takes about 2 to 3 weeks. The death benefit will be directly given to the beneficiary in a lump sum, allowing them to use this money to cover any final expenses, including funeral and probate fees, as well as any taxes and debts owed. So, I often tell my clients that even if they don't want to consider their descendants, they should at least calculate the taxes and debts they will leave behind and prepare this amount. After all, this is a responsibility we should take on ourselves. Some people choose to purchase a life insurance policy and designate a charitable organization as the beneficiary to receive a donation tax credit upon their death. This donation tax credit is a very effective and practical strategy. It allows you to give back to society and do good deeds, bring blessings to your family, and reduce your tax liability. If you are interested, feel free to contact me for consultation. Article 6. Give gifts before death. Giving gifts before death, also known as an inter vivos gift, is a very practical strategy. Donors can control how their assets are used and where they go. When an inter vivos gift is made, that portion of the assets is not considered part of the donor's estate. Thus, it does not need to go through the estate process, saving on probate fees. Additionally, an inter vivos gift can have significant emotional value because we can see our loved ones enjoy the gift while we are still alive. Many donors find that making inter vivos gifts gives them the opportunity to share their long-term plans and vision with their heirs and educate them on how to handle assets. By giving during their lifetime, beneficiaries can learn to manage wealth while consulting with the donor and adapt to inheritance, ensuring that everyone can better protect their family's wealth for the future. Instead of having the next generation start from scratch and struggle, it's better to provide a better platform so that the family's assets can be expanded and passed on more effectively. Many elders also choose to purchase life insurance for their grandchildren as a form of gift, providing lifelong protection for the children in advance, and achieving intergenerational wealth transfer. The benefits of purchasing life insurance for children as an intergenerational wealth transfer are numerous. I have also introduced this topic in my previous videos, so if you are interested, you can check them out. First, spend unsheltered assets such as cash or stocks. Since registered accounts and insurance company segregated funds can designate beneficiaries, these principal protected funds have the attribute of bypass probate. Therefore, the Canadian government recommends that after retirement, one should first consider spending unsecured savings to reduce the final estate tax. Here is a reminder for everyone. If there are any unused portions of the RSP at the time of death, the remaining amount will be withdrawn in a lump sum and taxed accordingly. The 8th point is to use final RSP contributions. On December 31st of the year you turn 71, if there is any unused RSP room, you can choose to make a one-time contribution before closing the RSP. However, this tax deduction does not need to be fully utilized in that year. It can be used at any time in the future. If at the time of death the individual's RSP still has unused room, and the spouse is not older than 71, then this room can be utilized to contribute money into the spouse's RSP account. This can convert a portion of taxable income into protected assets, thereby reducing estate taxes and various fees. However, this operation can only be completed within the year of death, or within 60 days of the following year. Article 9. Purchase permanent life insurance as an investment. This is the 3rd time life insurance has been mentioned in this table. It shows just how important life insurance is in asset planning. This mentions whole life insurance, which has appeared many times in my videos. Using dividend-paying insurance as an example, as long as you are insurable and in good health, the earlier you start purchasing whole life insurance, not only will the annual premiums be cheaper, the longer the funds grow inside, the more astonishing the benefits over time. Here, I want to share my own story. My dad was very aware of the importance of insurance. When our family immigrated, we bought insurance right after landing, just after the pandemic hit in 2020. Due to various reasons, I experienced severe insomnia and anxiety, but during the day, I had to muster all my energy to take care of my family and work, leading to significant physical exhaustion. Later, my father noticed my condition and told me that I didn't need to put so much pressure on myself. He said they had already provided me with enough security. Although I understand the importance of striving through my own efforts, I was filled with gratitude and emotion at that moment. Parents always plan long-term for their children. We can't accompany our children forever, but we hope that when our children think of us, their hearts are filled with strength and warmth, giving them the courage to overcome difficulties and pursue their life's goals and meaning. I am very grateful that my parents bought life insurance for me in advance. So when my sons were born, I also bought life insurance for them right away. It was because my parents had a strong awareness of insurance back then, that it has significantly reduced my burden now. I can say that among my clients, some are involved in insurance and others in various investments. However, not a single client has ever regretted purchasing life insurance. On the contrary, many have proactively requested to increase their coverage within a few years, and many friends regret not buying enough coverage when they were younger. We all know that investments can fluctuate in value, with prices going up and down. However, when it comes to insurance, the fact that you are insurable now means that the current price is the cheapest it will ever be. Moreover, the value of this investment only increases and never decreases, which is something no other investment can guarantee. For friends who own a company, you can also consider using the company's money to purchase life insurance for yourself. In the case of a corporate policy, the company must be the beneficiary. Let me give you a simple example. Mr. F used the company's assets to insure a $6 million policy. Upon his death, the policy appreciated to $10 million. The company receives $10 million, and after deducting the insurance cost and ACB, the money goes into the company's CDA account, Capital Dividend Account. This account is extremely important. It is clearly stipulated by the CRA and can be understood as a tax-free account from which a company can pay dividends tax-free. Only the money in the CDA account can be distributed as tax-free dividends from the company's assets. This way, Mr. F's beneficiaries can receive dividends from the company tax-free, making it the most effective way to transfer company assets to individuals. Whether it's an individual policy or a company policy, as long as the insured person is in good health and insurable, it is advisable to consider purchasing it as early as possible. This allows the policy more time to appreciate in value, achieving better investment results. Transferring property to joint ownership can change the ownership of assets to joint ownership, thereby reducing the assets that enter the estate process and lowering taxes and probate fees. However, doing so may result in losing control over the property, as any decisions regarding jointly owned assets require the consent of the other party. Additionally, the debts of the co-owner can also be forcibly repaid using the jointly owned assets. Therefore, this approach needs to be considered carefully. 11. Set up a trust fund. Many people have heard of trusts and believe that they are tools only for high net worth individuals and the wealthy. However, this is not the case. Trusts are a very common and effective way to manage and transfer assets. Simply put, a trust is a tripartite fiduciary relationship where the first party, the settlor, transfers property to the second party, the trustee, with clear instructions on how the trustee should manage the assets for the benefit of the third party, the beneficiary. Many of you might have heard that Joyce Cheng only officially inherited her mother Lydia Sum's 60 million Hong Kong dollars estate when she turned 35. Before this, she could only receive a monthly allowance of $20,000. When her mother passed away, Sally was not yet 20 years old, an age of naivety and lack of judgment, making her easily influenced. However, the trust structure played a crucial role in protecting the daughter, and Nally has the capability and maturity to inherit her mother's substantial estate. While we admire this wise mother, we should also recognize that trusts can extend the will of the grantor, properly plan assets, protect the estate, and safeguard the lives of family members. This is especially true when the beneficiaries are minor children or individuals with disabilities, as trusts are often used to ensure their well-being. There are many types of trusts, which can generally be categorized as inter vivos trusts. When establishing a trust, the trust becomes a legal entity that owns your assets. Therefore, assets transferred into and out of the trust are usually considered a deemed disposition, meaning they are treated as if they were sold. The sale price should be based on the market value at the time of transfer, and any appreciation from the purchase date is taxed at the highest marginal tax rate of the province of residence. The assets in the trust are protected from creditors. At the time of death, assets will not be made public, making it more legally binding than ordinary will provisions, and less likely to be contested. Additionally, trusts can serve many purposes. Common uses include family trusts, asset freezing, retirement planning, tax reduction, divorce agreements, and more, all of which can be planned according to needs. However, one thing to note is, in Canada, trusts have a 21-year rule, which means that every 21 years, the assets in the trust must be deemed as sold and taxed at the highest tax bracket, according to the CRA. To prevent people from using trusts to indefinitely avoid tax responsibilities, many choose to include life insurance in the trust. This is because at the 21-year mark, only the policy remains unaffected, while the rest of the assets must be deemed as sold and taxed in a lump sum. However, even with the 20-year rule, trusts play a very important role in aspects such as property division in divorce, protecting assets from being squandered by descendants, and tax deferral and avoidance. The 12th and final point is to make arrangements in case of incapacity. This is what I mentioned in my previous video as a power of attorney, which allows someone to act on our behalf according to our wishes when issues arise. I recommend that everyone who has critical illness insurance should also have one, because when a CI claim is made, It requires the insured person's signature. If an illness occurs and a person loses consciousness and is unable to sign, it may lead to issues with compensation. Therefore, it is essential to have a designated proxy signer. So, that's my comprehensive interpretation of the estate planning advice provided by the Canadian government. After discussing so much, we should realize that our goal should be to minimize the assets that ultimately enter the probate process. Through proper planning, there are many ways to bypass probate, making the distribution of the estate clearer and more controllable. This can significantly reduce taxes and probate fees, and you can also obtain additional tax credits through charitable donations. In terms of estate planning, we must collaborate with professional tax accountants, lawyers, and financial planners, maintaining mutual trust and active communication to create a suitable planning scheme. We often say that wealth does not last beyond 3 generations, perhaps because we have not reasonably planned and arranged our assets, failed to consider future generations, and lacked proper guidance. This can lead to a significant reduction in assets, or even insolvency. If you find my videos inspiring and helpful, please like and share them. If you enjoy my videos, feel free to follow me. If you have any specific questions, you can contact me for consultation. Thank you everyone. See you in the next video. Bye bye.